So as Andrew mentioned, I'm going to talk to you about the Chevron case. Those of you who are familiar with this case will know that it's a bit of a beast of litigation in all of its international aspects and other aspects. It's got intrigue, it's got allegations of judicial corruption and bribery and so on. I'm going to focus my remarks on that aspect of it that, that illuminates the law related to the enforcement of foreign judgments in Canada. Before we talk about the Chevron case in particular, let me just talk a little bit about the basic concepts related to enforcing a foreign judgment. And really start at the beginning. Those of you who practice litigation know that getting a judgment, sort of proving liability, proving damages, is sometimes only half the battle. You still, if a defendant won't actually pay the judgment, then you're going to have to take some further steps to actually enforce and collect on it. And there are a number of tools that you can use to engage the compulsory power of the court, including having a state actor go and seize assets of the debtor for the benefit of judgment creditors. And that's fairly easy to do when the defendant's assets are in the jurisdiction of the court that granted the judgment. The court is ready to help, knows the judgment, the tools are there. And that's a pretty straightforward process. But what happens if the defendant doesn't have any assets in that jurisdiction or doesn't have sufficient assets to satisfy the judgment that you've obtained? Well, there's nothing stopping you from going elsewhere where the defendant might have assets or could in the future have assets, as we'll learn. But now there's another hurdle, and that is you're going to need the assistance of another court in the enforcing jurisdiction. And you're going to have to convince them to help you. And this is a scenario that arises from time to time in Canadian courts. They receive requests from people who've obtained judgments in foreign jurisdictions and are asked to help enforce them. First of all, recognize the judgment and then enforce it. So when will a Canadian court agree to do this? Well, the test is pretty straightforward. The modern test was established in a case called Beals and Saldana from 2003. In that case, the Supreme Court of Canada basically extended the rules that apply to the enforcement of intraprovincial judgments and said we're going to apply these same rules to international judgments. And essentially, as long as you can establish that the foreign court that granted you the judgment properly took jurisdiction over the case in the first place, it's going to be presumptively enforceable in Canada. And the specific test that the Supreme Court articulated was that there has to be a real and substantial connection between the cause of action and the foreign court. If you've established that, the court had proper jurisdiction and it's presumptively enforceable in Canada. I say presumptively because there are certain defenses that a defendant can raise in opposition to a recognition and enforcement proceeding in Canada. So they could say, for example, the judgment in the other jurisdiction was obtained by fraud, although they have to do that on the basis of newly discovered facts, because if they could have raised that in the foreign court, they should have done so there. They could argue that there was a lack of natural justice in the foreign jurisdiction. So, an example would be they didn't get notice of the proceeding. The judgment was granted, they didn't have an opportunity to respond to the allegations. Canadian court will look not favorably upon that. There may be other principles of Canadian public policy that would militate against the enforcement of a foreign judgment in Canada. And the language used is that if the judgment's based on foreign law, that's contrary to our view of basic morality. So, for example, if the judgment was granted on the basis of a law that made distinctions on the basis of race that wouldn't be countenanced in Canada, Canadian court may be unhappy about being part of the enforcement of that judgment. So that might be a reason. But otherwise, it's a pretty straightforward test. It's not hard to do. So what does Chevron add to that? Well, just to foreshadow, Chevron raises the question, what if, in particular, it raises a lot of questions, but in particular, it raises the question, what if a defendant doesn't have assets in Canada? Will a Canadian court still entertain this kind of enforcement action? So just to give you a little bit of background, if you don't know about Chevron, the story starts in Ecuador. That's a map of Ecuador. and in a region called the Oriente. And Texaco was involved in exploitation and extraction of oil resources there. And there were indigenous communities in the vicinity that were concerned about the effects of this exploitation and extraction, claimed that it was causing environmental pollution, and really disrupted their way of life in a serious way. So they sued Texaco. And just to breeze through this, they started in the US, which is where Texaco sort of was. And that case was dismissed on the grounds that it ought to have been brought in Ecuador. So off to Ecuador, and to make a very long story very short, the villagers sued Chevron in Ecuador because by now Texaco had merged with Chevron. That's why we're talking about Chevron. And they obtained a very large money judgment there. Even after it was reduced on appeal, it was still $9.5 billion US dollars. The reason we're talking about recognition and enforcement is because Chevron refused to pay, and in fact fought the enforcement of the judgment in the United States. I alluded earlier to allegations of judicial corruption and bribery, and those were among the grounds that Chevron raised. So the plaintiffs went looking elsewhere in the world where Chevron might have assets. They brought proceedings in Argentina, Brazil, and what brings us here today is they started enforcement litigation in Canada. And in 2012, they commenced a proceeding in Ontario for recognition and enforcement of the Ecuadorian judgment. And for good measure, they, because they anticipated that Chevron would argue it didn't have assets here, they added Chevron Canada Limited as a defendant to the enforcement proceeding in Canada. And I'm not going to talk a lot about Chevron Canada, but just so you understand the piece, Chevron Canada is not a direct subsidiary of Chevron. It's 7 layers in. It's an operating company in Canada. It has its head office in Calgary. You can sort of understand why, based on those facts, that the plaintiffs sort of thought it was a juicy target. But you know, there were some problems, and there's a lot of facts surrounding Chevron Canada, but it never carried on business in Ecuador. It didn't have any connection to the Ecuadorian proceedings. So there were some challenges with the case against Chevron Canada. So the first thing that happened in the Canadian litigation was that the defendants challenged the jurisdiction of the Ontario court to even entertain the question of whether it should recognize and enforce the Ecuadorian judgment, primarily on the basis, there were a lot of arguments raised, but the primary one I want to talk about is that Chevron wasn't present here, Chevron Corporation wasn't present here, didn't have assets here. So no business of an Ontario court even looking into this matter was Chevron's argument. And what they said to advance their cause was that from a legal point of view, was that the Beals test, which remember talked about the fact that all you had to show was there is a real and substantial connection with the jurisdiction that granted the judgment. They said you should also have to show that there's a real and substantial connection with the enforcement jurisdiction, the Canadian forum. Because of course, that's the test we use in regular litigation. When a defendant isn't in the jurisdiction, doesn't consent to the jurisdiction, we look at whether there's a real and substantial connection to the jurisdiction before we as a Canadian court will assume jurisdiction over the dispute and over the defendant. So Chevron argues that that should also apply when we're talking about recognition and enforcement of foreign judgments. And that went all the way to the Supreme Court, which dismissed the jurisdictional challenge on all the grounds that were raised, including this particular ground, and said that that traditional test for assuming jurisdiction, that there has to be a real and substantial connection with the Canadian forum, doesn't apply to recognition and enforcement proceedings. And sort of explained why, both with reference to the purpose of this kind of proceeding and the idea of international comity, which is that courts should strive to respect the jurisdiction of other courts and assist them in the fulfillment of their judgments. The court's role in this, sorry, did I skip something? Right, remember the purpose is, we're talking here about an already adjudicated obligation, and the purpose of the enforcement proceeding is just to help fulfill it. So the court's role is not as an adjudicative body, the Canadian court's role. It's really just to facilitate. It's not exercising jurisdiction in the same way. The logic that applies to the real and substantial connection test isn't there in these cases. And there are a number of other grounds that were raised. Another important one to highlight is that obligations created by a foreign judgment are universal. There's no completing claims for jurisdiction. There's no problem with the Canadian court taking jurisdiction away from another court. Comity is important. Comity is about order and fairness to participants, these very lofty goals, and that would be undermined by requiring the defendant to have a real and substantial connection with the enforcing court, in particular requiring that they have assets here. And that's because, and this is really, I think, the key takeaway from the Supreme Court decision, assets are very mobile, right? Your bank account contents can disappear, go to another jurisdiction within an instant, a push of a button. And the court says, if jurisdiction over recognition and enforcement proceedings were dependent on the presence of assets at the time of the proceedings, this may ultimately prove to only benefit those debtors whose goal is to escape rather than answer for their liabilities, while risking depriving creditors of access to funds that might eventually enter the jurisdiction. In today's globalized world and electronic age, to require that a judgment creditor wait until a foreign debtor is present or has assets in the province before a court can find that it has jurisdiction in recognition and enforcement proceedings would be to turn a blind eye to current economic reality. So the court is really taking a very pragmatic and modern view to international commerce and business. Jurisdictional challenge ends. I've exceeded my time already, so I'm not going to take you through what happened after this, but suffice it to say that the parties are now into the merits. There were some dispositive motions that were brought, and that matter is now on appeal. Sorry. See, I had a lot of slides. Dispositive motions were heard by the Court of Appeal last week. So this is an ongoing story in Canada, and stay tuned. Given the history of this matter, it is probably going to continue for a long time. Thank you very much.